Good morning and welcome to the Supreme Court of the United Kingdom. This is the second day of hearing in appeals in judicial reviews by Margaret McQuillan, Francis McGuigan and Mary McKenna. We are currently hearing the submissions on behalf of the Police Service of Northern Ireland from Mr. Tony McGuigan QC, who I'll now invite to continue his submissions. Mr. McGuigan.
Good morning, my lords. I wanted to commence submissions today by examining our core propositions on the legal principles and developing those by reference to the Strasbourg jurisprudence on institutional, hierarchical and practical independence. Our core submissions are set out at paragraph 72 and following of our written case. Just for your reference, that's at 3868. If I can summarise at this stage, we say the police service does not lack the institutional or hierarchical independence necessary to review or investigate cases in which the RUC or the military are implicated. This is the effect of the Strasbourg decision in Brecknell, the United Kingdom. The Northern Ireland Court of Appeal did not reject the Brecknell analysis, but nonetheless made a finding that the PSNI, Legacy Investigation Branch, were not sufficiently practically independent to conduct the investigation without making modifications and changes. And we say that is, in effect, a finding of a lack of institutional independence. And you can see the outline of the court's order on this point, if the court can turn briefly to electronic page 227. And this is the Court of Appeal order in the McQuillan decision. And you'll see at paragraph 2, the court declared that the Chief Constable was obliged to conduct the further investigation in a manner that satisfied the state's procedural obligation under Article 2, which is the Secretary of State's limb of the case, and then declared that the Chief Constable was bound to promptly take steps to secure the practical independence of the investigators so they have the capacity to carry out an Article 2 compliant effective investigation into the death of Jean Smith. Now, we say it's wrong in principle to make adverse findings on this approach on practical independence before an investigative team and structure has been put in place to undertake the work in the first instance. And we will refer in due course to the decision of Lord Kerr in the case of Kelly in 2004, which I will come back to. And we say that what the court did in this case was to make or adopt an approach on practical independence without scrutinising, because it couldn't, because the process hadn't started, the actual approach taken by the PSNI Legacy Investigation Branch. They then read across that approach to the decision in the appeal in the Hooded Men. The Strasbourg jurisprudence, as we will see, demonstrates that the question of practical independence can only properly be assessed at the end of an investigative process, not at the outset. Yet the difficulty with these decisions is that the court has decided at the outset that the LIB could not demonstrate the appropriate practical independence without further modifications. We say it's also wrong in principle for the Court of Appeal to identify an obligation to demonstrate practical independence upon request by the next of kin before a review or investigation has actually been established. We say that imports a presumption of a lack of practical independence, which the police service have to displace before any investigation ever begins. Effectively, they are bidding for the right to conduct their own statutory investigations. In our submission, that undercuts the philosophy of the post-patent policing reforms, which were intended to remove the police from the arena of antagonistic public debate, as Lord Mandelson observed when recommending the patent reforms in 2000. So in outline, those are the broad submissions which we intend to develop this morning. It will assist the court if we reflect on the classification that's repeatedly used by the Strasbourg court when assessing questions of Article 2 independence. And one sees the formula repeated in multiple judgments, but perhaps if the court could turn up Jordan in the United Kingdom, that's at, the judgment is at electronic 5133 and paragraph 106 which can be found at page 5168. And one sees there the classic formulation on Article 2 independence. So for an investigation into an alleged unlawful killing to be effective, it may generally be regarded as necessary for the persons responsible for carrying out the investigation to be independent from those implicated in the events. This means not only a lack of hierarchical or institutional connection, but a practical independence. And those three concepts are in play in these appeals, and they have and import different requirements on public authorities. Our case is on the question of institutional independence as a baseline proposition that the Strasbourg Court has already found that the PSNI is institutionally and hierarchically independent of the RUC. It follows a fortiori the PSNI are also sufficiently institutionally and hierarchically independent of the military, security service, Secretary of State, and any other agents of the state who may be involved in legacy investigations. And we say the Strasbourg Court has made those findings in principle clear. It's been addressed in two Strasbourg decisions. Firstly, in the case of Hackett in the United Kingdom, which is an admissibility decision from 2005. You will find that at electronic page 4860. And this was an admissibility decision involving allegations in respect of a notorious case of a convicted paramilitary offender who published a book after his conviction alleging that his earlier admissions had been false in order to shield other members of his paramilitary group. The chief constable of the PSNI had directed that a detective inspector in his organisation and a senior detective from England examine the material in order to make further inquiries. And you will see at page 4862, the middle paragraph, the actions directed by the chief constable. You will see on the next page a summary of the complaints, and the appellant was arguing that the PSNI investigation lacked the requisite degree of independence from those implicated in the events, and that the involvement of the English police officer was not sufficiently independent from those responsible at that time. The court then considered the law, looking at the classic Article 2 formulations at page 4865, and observed that it has not been substantiated, this is in the third paragraph, that the method of appointment or the fact that the officer reports to the PSNI deprives him of the necessary ability to report objectively and without being influenced by any officers implicated in the events. As regards the limited nature of the investigation, this is the status of a preliminary inquiry into the credibility of Stone's assertions, and depending on his conclusions may in due course lead to further steps being taken. It goes on, given the preliminary nature of the investigation, which may or may not lead to suspicions arising against other persons, the court's not persuaded that the interest of the family requires any closer involvement in this at this stage. And then at 4866, you will see in conclusion, the court considers it premature to impugn the responsibility of the authorities to the allegations of Michael Stone. It's not possible at this stage to anticipate the outcome of proceedings or to assume the applicant will not be duly informed of any conclusions reached. So this was a case with features that are common to the appeals before the court, where there was a hierarchical connection between the investigating officer and the PSNI. There was a historical connection between the RUC and the PSNI, but the European Court considered that the Article 2 independence argument was inadmissible. Also, importantly, it considered that it was premature, not possible at this stage to anticipate the outcome of the proceedings. That, we say, is not the approach the Court of Appeal took in either the McQuillan case or the Hooded Men appeals. Lord Leggett.
They were satisfied with the arrangements that had actually been put in place for this particular investigation in Hackett. What I read the Court of Appeal in McQuillan as saying is that they were not satisfied that appropriate practical arrangements had been put in place for the investigation. So it's different in that respect.
Yes.
Obviously, once there are, then you have to wait for the outcome to see whether there's anything wrong with it. But that's not the ground on which the Court of Appeal decided this case.
My Lord, respectfully, what we say is that at the point where the Court of Appeal is assessing the actions in McQuillan, the LIB had not taken any action in respect of this. The Court's dissatisfaction was with what the HET, the predecessor organisation, had done. The LIB had not been able to take any steps. So we say, and there is a fundamental point about this, the true assessment of the practical independence and the authorities support this argument, as we'll see, requires the organisation to be allowed to establish its investigation and take those steps. And that didn't happen in the McQuillan case. That we say is quite fundamental to this analysis. And because it didn't happen, essentially what you have is a public confidence finding made in the abstract, which prevents PSNI from taking the first step. So my Lord's question, I think, exposes what we say is quite an important feature of both of these appeals. Can I turn, my Lords, to the second, perhaps more important Strasbourg decision on these points, and that is the Brecknell decision of the Strasbourg Court in 2008. You'll find this at electronic page 4811. And this decision was opened by Mr. Eadie yesterday for a different purpose, because of course it sounds on issues of the threshold requirements for a revival application in Article 2. And it's important and authoritative on that point. But it also speaks directly to questions of PSNI institutional independence. And you have Brecknell, as I've said, at 4811. The relevant factual aspects are set out from paragraphs 21 through to 24, and those are at page 4816 to 4817. If I could just summarise the position. Brecknell is a case which straddles the policing reforms. So allegations of RUC collusion emerge in the mid-1990s. The RUC began an investigation into that in 1999. That investigation continues into 2001, at which point the PSNI are the replacement organisation for the RUC. Or just pause because I see we've lost one of the judges. I think we've lost someone.
Lost Lord Hamlin.
Yeah.
Should I pause?
Yeah, if you would pause, please. Thank you. He's coming back. Lord Hamlin, can you hear me? Lord Hamlin, can you hear me?
Yes, I can, thanks.
Yes.
I don't know what happened. I lost it just when Bracknell.
Yes, well, we were referred to Bracknell powers 21 to 24, and the point was made that the facts, the investigation straddled the pattern reforms beginning in 1999, and the PSNI came into existence in 2001. And at that point, your absence was spotted. Mr. McGuigan, if you'd like to continue.
Yes, my lord. I was summarising the background of the case from paragraphs 21 to 24, page 4816, 4817, and I was making the point that it straddled the implementation of the policing reforms and the commencement of the PSNI in 2001. It's also a case where the PSNI investigation was taken up by the Serious Crime Review Team. You'll see that at paragraph 24, and thereafter by the Historical Inquiries Team, HET. So it had all of these elements, the RUC, the PSNI, and then the post-McCare package of measure reforms of the HET and SCRT involved in the investigation. Now, the applicant in Bracknell challenged the independence of the process, the allegations squarely made at page 4819, paragraph 34, contending that it wasn't compatible with Article 2, that there was the PSNI that had conducted the investigation into the allegations implicating the RUC officers. That's at the bottom of that page on paragraph 34. The argument advanced on behalf of the government commences at 4827, and you will see over the page at 4828, paragraph 64, the position being outlined there in response to the independence argument, that the investigations were independent. The REC personnel involved in the initial investigation had long since left the security force or had died. PSNI had undergone extensive reforms to be regarded as independent of the RUC. And in any event, the HET, which is now carrying out the investigation, was independent of both. The police ombudsman was also independent and in a position to investigate and monitor whatever HET had done. So the issue is squarely in play before the Strasbourg court, looking at these elements of the investigative toolkit. The case, as I said, it dealt with a range of issues, but the question of independence was addressed at paragraphs 76. You'll find that at page 4833. And again, a passage we place heavy reliance upon. The court would observe the initial inquiries were carried out by the RUC, which was itself implicated in Weir's allegations, as their own officers had already allegedly been heavily involved. They cannot be regarded as disclosing the requisite independence. Footnote 24 is to Ramsahai, a case that I will return to in due course. It was the RUC which carried out the interviews with those that named by Weir, which entrusted with the initial assessment of the credibility of his allegations. This must be regarded as tainting the early stage of the inquiries. The court recalls that PSNI took over from the RUC in November 2001. It is satisfied that PSNI was institutionally distinct from its predecessor, even if necessarily it inherited officers and resources. And then notes that the applicant hadn't expressed doubts about the independence of the teams. So that point of institutional distinction, we say, is critically important to the overall analysis of these appeals, because institutional distinction, when one reads the context of this case, means that the PSNI was institutionally independent of the RUC. And that's because of the way in which the investigations developed up to 2001 were then taken over by PSNI and HET. That's the only thing that can be meant by the court's finding in terms of institutional distinction. You'll see 76. Yes, the last two sentences of paragraph 76. This doesn't detract from the fact that for a considerable period the case lay under the responsibility and control of the RUC. In this respect, there's been a failure to comply with the requirements of Article 2 of the Convention. So the importance of that, we say, again, is if one can test it by posing a question rhetorically. Why did the court consider PSNI to be institutionally distinct? It was plainly because of the fundamental reforms to policing introduced via Patton through the legislation in 2000 and 2003. the enduring analysis of the European Court arising from Brecknell is that the PSNI is sufficiently institutionally independent to investigate the actions of the RUC. Absolute independence is not required, nor is it the test. Sufficiency is the key concept. And the Strasbourg Court was satisfied in 2008 that PSNI was sufficiently independent in terms of the institution and hierarchy to conduct an investigation involving the RUC. The effect of that, we say, is important for these appeals. There is no hierarchical or institutional bar to the PSNI investigating matters in which the RUC officers were implicated. But the Court of Appeal has found that the PSNI lacks the necessary independence to investigate the RUC interrogations in the Hooded Men, and that they lack the practical independence without further steps being taken to investigate the possible involvement of the military in 1972 in McQuillan. We say that insofar as these adverse findings in these appeals are based on an apparent lack of practical independence, the Court of Appeal was in error here also. And it may assist if we expose further the categorical distinction between the circumstances in which the Strasbourg Court makes an adverse finding on institutional independence and those cases where it makes an adverse finding on practical independence. Turning to institutional independence, first of all. Where the Strasbourg Court examines questions of institutional independence.
Mr. McQuillan, before you move on, is there anything in Brecknell which is concerned with institutional or hierarchical institutional independence of the military?
No, my lord, no. There was no military involvement in the Brecknell case. It was a question of RUC collusion, so it doesn't speak to that. But our submission is, evidently there was always an institutional disconnect between the RUC and the military at different command structures. That they operate in an entirely different framework. So if it was sufficiently institutionally independent from the RUC, we say it follows that it's sufficiently independent for the purpose of a military investigation. And that's important again in the McQuillan context, because the controversy, the enduring controversy about the McQuillan case is the possibility that a military round was fired and was causative of the death.
No doubt at some point in your submissions you will deal with how it came about that the findings were findings in the McQuillan case were carried over into the Hooded Men case by the Court of Appeal.
Yes.
Notwithstanding the fact that the Court of Appeal observed that each case had to be considered on its own particular fact.
Yes, we'll come back to that. There was a direct read across.
Thank you.
So, my lords, returning to the analysis of institutional independence, when the Strasbourg Court looks at that concept, there is a common feature which one finds in almost all the cases. What is offensive in Article 2 terms is where an investigatory body investigates itself. And that is exposed in Brecknell, which was the RUC looking at an RUC process. It was also the case in the Jordan and United Kingdom decision, which I've already referred to, which was again the RUC investigating RUC action. The point's illustrated in a non-Northern Ireland context in the decision in Ramsahai, which again is the footnoted reference in Brecknell. And you'll find Ramsahai at electronic 5256. And this is a case involving two state actors, the Amsterdam police and the public prosecutor in Amsterdam, who was engaged in an oversight role in respect of the Amsterdam police. I don't think I need to take time on the facts of this case, but it's a well-known authority in this area. The question of independence is addressed at page 5309 from paragraphs 333 through to 341. And the key point is at 337 that the court found the violation of Article 2 in its procedural aspect in this death because it engaged the responsibility of a public authority which was carried out, where the investigation was carried out by direct colleagues of the persons allegedly involved. Supervision of another authority, however independent, was not a sufficient safeguard. So classically again, the investigators were part of the same organisation that was being investigated, therefore institutional independence difficulty. One can contrast the approach the Strasbourg Court took with the role of the public prosecutor, which appears on the same page at 5.3.10. You'll see here the police investigation was carried out under the supervision of the Amsterdam public prosecutor, who had overall responsibility for police work. And while the court was expressing reservations and concerns about that, at paragraph 345, you will see they said it would have been better if the investigation had been supervised by a public prosecutor unconnected to the Amsterdam police. Even so, they take the note of the independence of the prosecution service. They also note the possibility of review by an independent tribunal, which the applicants made use of. And over the page, you'll see there was no violation in respect of the public prosecutor. So this illustrates the different approach, where you have investigations, a linkage between the investigators and the investigated body, potentially Article 2 independence breach, where you have a connection, as in the case of the public prosecutor, then no breach, and the court will exert greater scrutiny over an evaluation of the investigative process in that context. So, returning to our baseline proposition, we say the Strasbourg authorities show that there's no issue with the hierarchical institutional independence of the PSNI. That was the position in 2008. It can only be stronger, given the elapse of time. 13 years later, with an ever-diminishing number of officers with RUC service, the argument of PSNI not having sufficient institutional independence should no longer, we say, carry weight. Having established that baseline proposition, we say any concerns about PSNI independence in the context of these appeals can only arise under the heading of practical independence, because we have already established the Court of Appeal's position was to accept the Brecknell analysis. And where one's dealing with questions of practical independence, there are two key points arising from the Strasbourg jurisprudence. Firstly, practical independence requires a fact-specific consideration of each case with respect to the quality of the actual investigation, concrete outcomes of the investigative process. Second point is that that exercise is conducted at the conclusion of the investigative process, not at the start or before the start, as occurred in this case. The Strasbourg authorities are to the effect generally that practical independence can come into, sorry, Lord Leggett, I didn't see your hand.
Surely if you know when the investigation is set up that, for example, there are going to be some former members of the RUC on the team, and that the RUC's past actions are significant for the investigation, then you don't have to wait to the end to know that practical independence has not been secured for the investigation.
My Lord, that is answered in effect by the importance of the reforms and amendments, the LIB Code of Conduct, all of the materials that we've put before the Court of Appeal. This court, which demonstrate the careful structures put in place to ensure that where that kind of actual identifiable difficulty might arise, that there are processes in place to neutralise it. And that's the case here, as you've seen from Mr. Wright's affidavit. He says that if there's an issue, we can put together a team that doesn't have any RUC involvement at all. That can be dealt with at the outset.
I accept that, but I'm putting to you that if that is not done, for example, then you can know at the outset that it's not a satisfactory arrangement.
Yeah, there will be that.
You accept that?
There will be.
Say that in that case too, you have to wait to the end, knowing that it's been set up in a way that is not calculated to secure independence.
Well, that will be an exceptional case, but the processes are in place in order to address that. And so in those scenarios, if there's an objection raised, then you may not necessarily have to wait to the end. But at the level of generality and in these appeals, of course, the investigation hadn't been set up. The team hadn't been put together. There wasn't anything that the court could work with in order to make that kind of presumptive finding, which displaced the ability of the organisation to conduct the investigation.
Well, it may come down to quite a narrow point, because you say they should have waited till the investigation was set up. The court said the Chief Constable had not condescended to say what arrangement he intended to put in place. And given that the previous investigation was tainted by a real possibility of bias, he needed to show, when he does set up the investigation, that this one wouldn't be.
Yes.
What's wrong with that?
Well, the difficulty he had, of course, was that he was under challenge and was unable to actually put together an investigation team at that stage. That was the very issue in the case. It was a preventative step being taken in order to stop the Chief Constable from setting up the process in the first instance. So the Court of Appeal does criticise him for not having condescended to explain the detail, but of course he couldn't because the litigation prevented him ever getting past first base on the point. Again, we say all of this cuts across the fundamentals of the post-patent policing reforms, the idea that there's a presumption of independence and there's a presumption that the police will be able to set themselves up in a way that is compliant with the convention, and that the Court of Appeal has been, we say, unduly critical of the Chief Constable in that context, and in a way that doesn't align with the principled approach the Strasbourg Court has argued for.
Why did the litigation prevent him from saying, if I'm allowed to set up a team, this would be my team?
I don't think it prevented him from saying those things, my lord, but the litigation stopped the process and there wasn't a team convened at that juncture. So the LIB is an organisation which you've seen constantly changes, its profile changes. You couldn't predict in a year's time what the profile is likely to be. So it's an issue that's got to be assessed based on the realities of the situation at the time. And this litigation interrupted the process. The police were always saying they were willing to do it. My lords, in terms of the types of case that give rise to practical independence problems, one can illustrate again the way in which the Strasbourg Court has dealt with this. There are multiple examples in the papers before the court, but to take two to illustrate the issue, Nakova, Grand Chamber decision of 2006. You'll find that at electronic 5186 for the beginning of the judgment. It's a case involving two conscripts from the Bulgarian army who went absent without leave, were being pursued by military police, and in an incident were shot and killed as a consequence. And the issue was about the quality of that investigation and whether or not it was sufficiently independent. And just to highlight for you the type of thing the Strasbourg Court was examining in that context, you will see that the general principles are set out at EF 5210. And the court's critical findings on practical independence are found at paragraph 115, that's page 5211. And the issue there was there were indispensable and obvious investigative steps that were not taken. In particular, various evidential opportunities weren't addressed. The investigator and prosecutors ignored highly relevant facts. Forensic opportunities weren't supported. And you'll see at 117, the Grand Chamber endorses the Chamber's view that such conduct on the part of the authorities was a matter of grave concern, cast serious doubts on the objectivity and impartiality of the investigators and prosecutors involved. So looking back, you can see a practical independence problem because one has an entirely ill-conceived, slipshod investigative process. That's a world away from the situation that we're considering in these appeals. Similarly, in the Northern Ireland context, you have the decision of the Strasbourg Court in McCare. We've already looked at it, but you find that commences at electronic 8907. And this is a case involving the RUC investigation into a police shooting in 1983. And paragraphs 127 and 128, again, note the matters that were of serious concern, that attempts have been made on the instructions of a senior officer to conceal information from the investigation. So senior officers were directing others not to give candid accounts of their involvement in a shooting in a manner that disrupted the process of the investigation. Again, an obvious instance of a practical independence problem viewed in retrospect.
The page number of those paragraphs, please.
Page number for those is 8957, my lord.
Thank you.
We say here in the McQuillan case, the scenario is fundamentally different. The LIB hadn't started the investigation. They did not pass go. There were no practical failings to assess. In the context where we have the baseline of institutional independence, the court finds that they cannot, as constituted in theory, commence the process without introducing other changes. We say that's wrong in principle, but also fundamentally damaging to public confidence in the reformed police service in Northern Ireland. If they have to bid for their ability to conduct an investigation in a polarised and partisan society like Northern Ireland, that in itself is damaging to public confidence. Yet oddly, public confidence was one of the key features that led the Court of Appeal to make the findings it did on practical independence in this case. And you'll see from paragraphs 153 to 156 of the Court of Appeal judgment, that's electronic 265. The Court of Appeal introduced the concept of the application of public confidence via the Porter and McGill test, being engaged in this context. I should say we accept that public confidence has a role in terms of being one of the objectives of the Article 2 procedural obligations. So there is a place for public confidence, but it is not a legal test, and it's not a legal test articulated anywhere by the Strasbourg Court. And we say the Northern Ireland Court of Appeal was wrong to endorse the application of a Porter and McGill test in the Article 2 context. Lord Leggett.
Porter and McGill doesn't say, does it, that you have to look at public confidence as a matter of practice, as it were, or look around, take a view about whether people will in fact be confident. It says you must postulate a fair-minded person, assuming them to have no prejudice, and ask whether that person would think there was a real possibility of bias. Well, if a fair-minded person would think there was a real possibility of bias, it's not going to be an impartial investigation, is it?
Well, Lord, the issue we have with the Porter and McGill test, which I'll develop, is the Porter and McGill test is of application in the paradigm of adjudicatory bodies, tribunals, judges, courts, and the question of whether or not they have a sufficient appearance of independence, which is obviously critically important in that paradigm. The difficulty is translating that across, either by way of common law or Strasbourg analysis, to the paradigm of investigation. Now,
well, I see that as a matter of legal analysis and actually relying on Porter and McGill as a direct authority. But if you have an investigation where a fair-minded person would think that there's a real possibility that the investigator is biased, it's not going to satisfy Article 2, is it?
my Lord, again, one makes a distinction here between a concern about an individual officer, a specific factual circumstance, or an application to an entire organisation. And there's a fundamental issue there. If one's suggesting ab initio, there's a problem with perception with respect to an entire organisation. We say that's different from having a concern ab initio about the possible involvement of a special branch officer or someone who's obviously had a connection with the past. And the difficulty here is the Court of Appeal have conflated those points. They don't observe those fine distinctions. So there is a problem in legal principle. I propose that, which my Lord I think accepts. But there's also a problem of practice in the way in which this is done in this case. And there's a problem in terms of the approach the Strasbourg Court has taken on this very issue. Because whether one is looking at the Porter-McGill test in common law or looking at it in the Strasbourg context, one shouldn't readily read across these requirements to the Article 2 procedural obligation. And perhaps
I thought what it was applied in this case was because Mr. Justice McGuigan found that in the Het investigation, a fair-minded person would consider there was a real possibility that the investigation was biased. That was his finding.
Yes, that's his finding.
That mentioned it. inexorably that it hadn't been an Article 2 compliant investigation?
Looking back, my lord, looking back
Yes.
at what it did, then the question is, now we now have a different entity, post-Het. We have another phase of reform. We have the legacy investigation branch, which is different, has different policies, which addresses the various concerns, which is, all other things being equal, about to commence this investigative process. Is it the case that one reads through an institutional bar because of the Het approach, or does one take the approach of allowing them to conduct the task and then assessing any feelings at the conclusion, knowing that there is the facility for judicial oversight through court processes, judicial review, the police ombudsman, and so forth. So we
I think you need to address the actual decision of the Court of Appeal, because I don't think they said that there was a real possibility of bias in this investigation before it had happened. They said you needed to take account of the fact that there had previously been an investigation which was tainted by the possibility of bias, and that was a relevant factor that, amongst other things, indicated that some special arrangements needed to be made this time, of the kind that had been made in Hackett, for example, and of the kind which the Chief Constable has in fact made in this investigation.
Yes. Well,
and you have to persuade us that there was something wrong in principle or in law with that conclusion. It's no good setting up false targets to attack.
of course not, my lord. I accept that. We say that's not the target we're attacking here. We say I've shown the Court of Appeal order, what the Court of Appeal is saying. We say that in effect, that's the importation of an institutional independence bar without affording the opportunity to develop the investigatory process through LIB. But I'll come back to the judgment in due course, my lord. I wanted to consider the decision of the Grand Chamber in Tunc versus Turkey, which goes to the issue and the role of public confidence in an Article 2 procedural investigation. And this authority can be found at electronic page 5382. This is a decision that actually wasn't examined by either the High Court or the Court of Appeal below. And we say it's important because it sounds directly on the question of practical independence and on the role of public confidence and on the interplay between the Article 6 fair trial protections and the Article 2 procedural obligations. We say this is a core issue in these appeals. And you'll find that judgment, I've said, at 5383. The factual background is set out at paragraphs 11 to 19. It's a military case. Soldier, sergeant on duty, guard duty, dies of a gunshot wound. There's only one other soldier in the vicinity. The wounds appear not to be consistent with suicide. The prosecution service decided not to prosecute, and the next of kin appealed that decision to the military court. So there are issues here about the independence of the investigators and also about the role of the military court because of the obvious connection with the organisation. And one sees that at page 5389, where there's a discussion of the discussion of the background of the case. It's also a case where the next of kin appealed to the military court about the prosecution decision, and the court directed the investigators to go back and broaden their remit and look at the matter again. So there are phases of the interaction between the investigatory process and the court. The chamber decision was to the effect that there was a breach of the Article 2 independence obligation, and you'll see that to be found at page 5402. Paragraph 140. The chamber decision was that the investigation had not been independent based on the regulations in force at the time, under which if 3 members of the military court did not enjoy all the guarantees of independence. There's a reference to the Gurkhan case in the indented paragraph, and then a quote from paragraph 131 of that decision. that the court had misgivings as to the impartiality of the judicial body responsible for the final review of the decision, and the Chamber found the Article 2 breach. The government's argument before the Grand Chamber, you'll see at 142, they contested the independence aspect. At 143, they alleged the Chamber had carried out an abstract review, whereas in their submission it was necessary to take into consideration the particular circumstance of each individual case by examining investigations as a whole with the role and specific conduct of the various bodies involved. And they note the importation of the Article 6 reasoning into the Article 2 context, but that these requirements weren't identical. The applicant's arguments are set out. Their challenge on investigation independence is at 159 through 161. That's page 5405. And the argument here was appropriate to transpose the Article 2 requirements on public, or Article 6 requirements of public confidence to the Article 2 context. So this is a Grand Chamber decision on the issue of principle about the role of public confidence in the assessment of investigatory independence. And the decision on this issue is found at page 5412 from paragraphs 217 onwards. At 217, they identify the link between Article 2 and Article 6. 219, the court says that it considers it useful to provide some clarification on the requirements that the investigation be independent for the purpose of Article 2, particularly whether the authorities in the broad sense must meet similar requirements as those which prevail under Article 6. And there are a number of important statements of principle in this judgment which we say are relevant to the analysis of this case. First of all, at 220, they identify that the requirements of Article 2 and Article 6, the safeguards that are applied in respect of fair hearings, are not to be assessed in the same manner as the Article 2 safeguards. There's an observation at 221 about the different requirements of an Article 6 investigation. At paragraph 222, the court reinforces the need for a concrete examination of the investigation in its entirety, and then sets out a range of decisions that sound on difficulties of practical independence. 223, they say there is no requirement for absolute independence. The question is whether they are sufficiently independent of the persons and structures whose responsibility is likely to be engaged. And again, that sufficiency, we say, is a key question in a case where it's already been established that PSNI are institutionally independent. 224 is also important. They say in a case where there's doubt about independence, institutional independence, although it's not decisive, it will call for stricter scrutiny on the part of a court as to whether or not the investigation has been carried out in an independent manner. So looking back, if there are reservations about institutional independence, then it's not a bar or a knockout blow. It involves heightened scrutiny of what in fact took place. Paragraph 225 identifies the general procedural requirements in Article 2, that's independence and the other elements, and suggests a holistic approach to them. So these are interrelated. Each of them taken separately does not amount to an end in itself, as is in the case in respect of independence requirement of Article 6. So independence is not itself something that is fundamental to the Article 2 process. It is one element, and there will be cases where one has reservations about independence, but nevertheless the process can continue and be permitted to reach its conclusions. Interestingly then, paragraphs 227 through to 230 set out examples of Turkish and Romanian cases where the Strasbourg court had earlier made adverse findings of institutional independence. So adverse findings about the particular police force. That organisation then in a later case coming before the Strasbourg court had investigated again. But in those circumstances, the court was prepared to accept there had been no breach of Article 2. So even where there are institutional independence difficulties, the court has been prepared to find, based on an actual analysis of a later investigation, that there's been no violation and no breach. It hasn't adopted an approach of saying you can't start, or you can't start unless you make changes. It has, in each case, in those scenarios, both in the Turkish and Romanian examples set out there, allowed the process to continue without an Article 2 breach. In the Tunk case, as I said, there were issues about the investigators and issues about the court. Sorry, Lord Leggett.
To say the court has allowed the process to continue in all these cases, the investigations have been completed, which is quite likely by the time a case gets to Strasbourg, often many years later. So obviously in that situation, it's looking back retrospectively and saying, well, was it an effective investigation? But it's not saying you can't ever say before the investigation starts that it's not going to be an independent investigation. That wasn't an issue that arose.
Yes. I think that's a fair point, my Lord. It's probably one of the limiting features of using the Strasbourg jurisprudence as an analytical tool, because it's almost always going to be a look-back exercise. I have to accept that point. But we say this is helpful insofar as it illustrates the types of considerations the court takes into account, and the scenarios where it's prepared to allow, prepared to allow is not the right phrase, but it has found no flaw with bodies that it had previously considered to have an institutional difficulty, who thereafter discharge a perfectly diligent and appropriate investigation, which we say is what would happen in this context.
Was Hackett an exception? Was that a case where it hadn't yet taken place or been completed, the investigation? Because the court was saying, well, they've set up a process with an independent English police officer and another officer who wasn't in the RUC, and that's independent.
Yes, Hackett was a case that was underway, but wasn't at the end of the process. Again, importantly, the decision was to the effect that it was premature to interfere at that stage, let it run.
Well, that was because they were satisfied with the arrangements that had been set up. If it had been two former RUC officers, they might not have been.
Yes, but again, my Lord, well, we can look, court can due course look at the facts of Hackett, but the facts of Hackett are very similar to the scenarios that we're looking at. It was an officer brought in who was actually under the institutional control of the RUC in the conduct of that investigation. So it wasn't an entirely separate seconded entity or anything like that.
In Hackett, if the court had been entirely satisfied, they wouldn't have said it was premature. They'd have said there was nothing in this. I mean, the fact is that you can say in your favour, Mr. McLean, that Hackett envisaged an assessment at the end of the process.
Yes.
Could I ask more generally? I mean, the concept of independence and the concept of absence of bias are not the same.
Yeah.
For example, in the field of arbitration, there are systems where institutions will impose obligations of independence and obligations of absence of bias. And there are other legal systems, including the English law, which doesn't impose a separate requirement of independence, but simply imposes an obligation of absence of bias from the part of the decision maker. What I would welcome is some assistance on the basis on which the Court of Appeal has sought to make the aim of public confidence a tool for bringing into the legal test a question of absence of bias.
Yes, my Lord. Okay. I'll address that. I think I've sketched the
You've sketched it out, but I'd like a bit more help in that if you can at an appropriate point.
Yes. Lords, I think I'll come to that point in a moment. We say the Tunk authorities of particular assistance. It's perhaps unfortunate that even our part wasn't drawn to the Court of Appeal's attention, because it's a caution against importing into this area Article 6 type concepts of public confidence, perception, Porter-McGill type bias. It is notable that the Strasbourg Court has never applied any such freestanding test of public confidence. As we said, ensuring public confidence is an objective of the Article 2 procedural obligations, but it isn't a test. Sorry, Lord Seals.
Yeah, sorry, it's just on a point of fact. Do I understand you correctly? Neither side drew the Tunk case to the attention of the court below, is that right?
That's correct, my Lord, yes.
You used a formula below saying it was unfortunate they hadn't considered it, which slightly masks the fact that it hadn't been drawn to their attention. But that is the fact, that it just wasn't.
Yeah, sorry, I mean no criticism of the court. It was not drawn to the court's attention. It's a Grand Chamber decision on point in 2015, but it wasn't before the court.
All right, that's helpful. Thanks.
We say that the import of TUNC on these issues is that the case law on practical independence and Article 6 case law on bias shouldn't be elided. Article 6 mandates fair trial, impartial tribunal. The bias case law requires a subjective analysis of an individual judge's approach and a wider objective analysis of any other circumstances in terms of doubts about the impartiality. A police force doesn't exercise any adjudicative function. It's an entirely investigative paradigm. So we say the Court of Appeal was wrong to draw in the Porter and McGill test into this context and apply it in an Article 2 case in terms of jurisdiction. The relevant passages of the McQuillan judgment are 154 through to 156. That's electronic 265. And you'll see, if you turn that up, 154, there's an importation of Porter and McGill, reference to Lawal and Northern Spirit. Again, a case about the perceptions of an employment tribunal. And those sentiments about public confidence must be read in that context. 155, the Court of Appeal say they consider the Porter-McGill test relies on Strasbourg jurisprudence, and they cross-refers to Houschild and Denmark. But Houschild and Denmark is another Article 6 case. It's not an Article 2 case. So it's importing, again, we say, the wrong concepts into the different paradigm that's applicable in this area. So those authorities, we say, are unhelpful in that regard. So turning to where we say the Court of Appeal went wrong in McQuillan, we say, firstly, there isn't a reason in principle to find that LIB ab initio at the outset would not be capable of starting the investigatory work. There's no institutional or hierarchical connection. They don't share personnel with the RUC. The staff are different from the HET, which was abandoned in 2014. And the procedures it uses are all now entirely in accordance with the HMIC critique advanced in 2013 and 2015. So we say it's entitled and was entitled to be judged on the final quality of his work, as the Strasbourg Court has repeatedly said in this context. That's the first difficulty, we say, with the reasoning. Second is the court, we say, made an error in calling for further practical measures to be, as they put it, injected into the process in order to bring in independence. And we say that's an error because it's based on an inappropriate incorporation of the Porter-McGill Article 6 jurisprudence into Article 2 independence. So it's a wrong concept being imported in. It's applied then at an institutional level, not at the level of individual officers. And it's used in order to preemptively prevent the PSNI from discharging its statutory function. As I've said, we don't dispute that perceptions and appearances can be important, but they're addressed by having appropriate procedures, policies, codes of conduct, all of which are part of the furniture of contemporary policing in this jurisdiction. We say the Court of Appeal should have adopted the approach of Lord Kerr when he determined the case of Kelly. And you'll see Kelly, I just divert to that briefly, at 4724 of the authorities bundle. And Kelly's a Northern Ireland case, obviously, about concerns about an investigation into an historic murder. And it was a case where there were original concerns about the quality of the RUC investigation. You'll see the facts set out at 4724, paragraph 1 and 2. Then at paragraph 20, you will see, that's page 4727, the shortcomings in the original investigation are highlighted. Various practical difficulties there with the quality of that investigation. Then it was proposed to address that by having an officer who was with the PSNI under their management and control, but who'd been seconded from England. And you'll see that detail set out at paragraph 21, page 4728. And the applicant's complaint was it wasn't independent because he was already seconded to the PSNI before he was appointed to head the investigation team. The team was made up from officers from PSNI, which were in effect the same as the RUC. And there were close ties and so on that caused the difficulty. Lord Kerr's approach from paragraph 27 through to 34 is, we say, illuminating. He, at 27, notes no breach has yet been established, so it wasn't necessary for him to decide whether they were obliged to hold an Article 2 inquiry. You'll see at 28, there was no reason to conclude at present that the investigation would be other than rigorous, and it was suggested that the police could never be Article 2 compliant, and he refers to a series of cases about the independence of police investigating a death. But it's not been suggested that in every case where collusion is alleged, an independent police force must be engaged. At 30, he refers to Shanahan, and he says it's clear from those passages that the court concentrated on the actual investigation and the manner in which it was in fact carried out in order to determine whether there had been a breach of Article 2. It seems to me clear that such an examination would also be required in the present case before one can conclude the actual investigation was not sufficiently independent. Until the investigation has been conducted, one has an opportunity to gauge whether the detective has demonstrated sufficient zeal in pursuing relevant lines of inquiry. It's impossible to say he will not be independent. It certainly has the capacity to be so if the investigation is conducted rigorously and fairly. He then, at 34, notes that there's cause for concern about the investigations to date, but it would be wrong to assume that because the investigations have already taken place may prove in the final analysis to be pitifully insufficient, the present investigation will be similarly afflicted. If properly conducted, has the potential to ensure the procedural requirements can be fulfilled. That approach, we say, is the correct approach. That's the approach that should be adopted in McQuillan, should have been adopted in McQuillan, the approach that should have been adopted in respect of the hooded men. And ironically, in the judgment in the Court of Appeal said they're following the approach in Kelly at paragraph 173. And we say that's, in fact, they're clearly departing from it. So this was the correct analysis and the correct approach, and the Court of Appeal departed from it and didn't follow the path that Lord Kerr had so carefully charted in Kelly. The third problem with the McQuillan judgment, we say, is the requirement that the police demonstrate in advance their capacity for independence by engaging in an iterative process with the next of kin about their practical arrangements. There is no legal obligation, either in Article 2 or anywhere else, that gives rise to such a requirement. And it's, again, illuminating to see where the Court of Appeal turned in order to fashion that obligation. It's at paragraph 175 of the judgment, and that's electronic page 272. The source of the obligation was a requirement, as the court said, arising from the Belfast Agreement. You'll see that at paragraph 175, page 272. Reference to the text of the Belfast Agreement says accountability includes the explanatory and cooperative sense of communicating in order to maintain trust. And those beliefs and explanatory aspects of accountability require the Chief Constable, when requested to do so, informs the victims as to practical arrangements. So a legal obligation fashioned out of the Belfast Agreement. And we say that's an entirely novel departure for the Court of Appeal. And we say that the Belfast Agreement cannot be the source of that kind of legal obligation. It doesn't give rise to enforceable legal obligation notoriously. It is a multi-party agreement. And we say the Court of Appeal has repeatedly accepted that, including in the decision of McCord. You'll find that at electronic bundle page 7153. Again, judgment of Lord Stevens, page 7165, where he sets out, again, at paragraph 45, the fact that the Belfast Agreement doesn't give rise to legal obligations with the force of law in that context. So we say this requirement for the Chief Constable to bid for the capacity to conduct his own investigations cannot be found in the Belfast Agreement. In fact, it's antithetical to the underlying concepts of the agreement. It didn't give rise to any such obligation. Now, we say those errors in the McQuillan decision were then read across directly to the decision in the Hooded Men. It's a slightly differently constituted Court of Appeal. Sir Paul Girvan was in McQuillan. Lord Justice Deany sat in the Hooded Men case. And the peculiarity of the Hooded Men decision was that was a case where the Court of Appeal found that Article 2 was not engaged, unlike McQuillan. So Article 2 is not in play in Hooded Men. But nonetheless, the court found that the arrangements for this particular investigation lacked the practical independence necessary to meet the Article 2 obligation. Well, if the obligation wasn't in play, we say that's to condemn the police service for something that they weren't actually required to do. And the issue was about the quality of response by an HET researcher to an allegation that there was authorization at ministerial level of torture, cruel, inhuman, degrading treatment. And we say when it's analysed fully, there's very limited scope for criticism in that context. But it is a case, again, where PSNI were willing to engage in an investigative process. There was some criticism of the quality of the investigative work, but they were willing to take the next stages, remedy that, and deal with it. But the Court of Appeal, applying McQuillan reasoning, said, in effect, they could take the matter no further, applying an institutional independence bar to their processes. And what was involved in the Hooded Men case, of course, was these officers investigating events of over 50 years ago in respect of relationships where they had no linkages. With the Brecknell concept firmly in mind, they were institutionally independent. And we say the Court of Appeal, by applying the McQuillan reasoning in this context, has again undercut the issue of confidence in public policing. If McQuillan is wrong in principle, then it follows that the decision of Hooded Men is also wrong, because it adopts exactly the same reasoning, but with much greater impact. Because McQuillan was about police investigating military. Here we're talking about police investigating the conduct of the RUC in an Article 2 and Article 3 context. That will embrace almost everything that happened if Article 2 extends back to 1966 over a period of 50 years. So one can see immediately why there is a concern on the part of the Chief Constable in that regard.
Could you just give the reference in the judgment? It would be helpful, beginning to where in the Hooded Men case the Court of Appeal dealt with independence.
Very good. Can I just, I'll come back to that momentarily. My colleagues here.
One point is possibly, isn't it, having accepted that it was a specific fact, case-by-case analysis required in McQuillan, they possibly didn't apply that approach in the Hooded Men.
Yes.
But I can't remember I can't find the exact passage at the moment.
If I don't get back to it immediately, I will either now or in response flag the point. So we say there is a fundamental conceptual difficulty in the Hooded Men case, given that Article 2 is found not to apply. The court adopts an unusual approach on this point, because it finds fault with the Chief Constable on a legitimate expectation argument. And the argument was, again, oddly constructed. Article 2 doesn't apply, but a legitimate expectation has been generated and frustrated. Therefore, PSNI LIB cannot meet the Article 2 standard of independence. We say it's a ultimate non sequitur at the heart of the analysis. But even then, we say, if one actually analyses the expectations that were in play in this case and goes back to what the issue was, it all arises from the uncovery of a memo written by Merlin Rees, who was the Labour Secretary of State following on from the Conservative government, where he made observations about the possibility of torture. And the Rees memo can be found at 3334 of the bundle. And that was the core document that was produced in the RTE documentary. That was the only document that was provided to the PSNI. They were asked at the policing board what they were going to do about it, and the Chief Constable replied that they would assess any allegation or emerging evidence of criminal behaviour from whatever quarter, with the view to substantiating such an allegation and identifying sufficient evidence to justify a prosecution and bringing people to court. In effect, he restated his Section 32 duty to investigate. So given that text, which was an archival document from the 1970s, he then dispatched a researcher to Kew to see what this was all about. And the researcher duly went and discharged the task and put the document in its context, including a reprisal memo by Merlin Rees, where he said at page 3343 that on reflection, actually, he had compressed the record rather too starkly and retreating from the suggestion that was ministerial authorisation. And of course, the court will see that from the revision judgment in Strasbourg, which Lord Reid was part of the court, this very issue was considered and not sufficient to mandate the reopening of the case. So the legitimate expectation generated was, we will look into this to see if there's anything else there. Researcher was dispatched to do that. He did so, and there's a detailed report provided by him, which is open to criticism, obviously, at the margins, but nonetheless, we say doesn't amount to the frustration of a legitimate expectation, because LIB said, we're quite prepared to take it further. We'll examine this matter further. And any expectation, if it hadn't already been discharged, could be discharged in the future. But the Court of Appeal said, that's the hook, that's the failure. You haven't discharged a legitimate expectation, therefore this sounds on public confidence. And that's found at paragraph 114 of the judgment. That's page 1924. And also addressed at page 1907, paragraph 47. Yes, sorry, I'm answering questions here that were posed to me earlier. Lloyd Jones asked about the transposition of the McQuillan finding into hooded men. That's found at paragraph 47, page 1907. And the reference at page 1924, that's paragraph 114, is about the legitimate expectation problem giving rise to a public confidence issue. The court can see the actual research that was done by PSNI HET at page electronic 3509 and at 3513 to 3524. So the second of those is a 11-page report by the police into the National Archive documents. Sir Donald Deaney found this informative and helpful. The majority considered that it gave rise to a public confidence problem. But it is a thorough analysis of what was very limited documentary material. And in our submission, cannot properly either be a breach of a legitimate expectation nor give rise to a public confidence feeling in this context. And we say this is also a misapplication of the Porter and McGill test for the same reasons that we've said earlier. It's a misapplication of Brecknell. And it's in a context where, sorry, Lord Leggett. My Lord.
Did they actually make a finding or a conclusion about this? I mean, all that there is at 114 is a passing comment, as far as I can see. It says that may raise an issue about whether there's likely to be public confidence. I mean, is that a ruling of the court or just an observation, which may or may not have gone too far?
Sorry, I'm chasing down the reference here electronically.
It doesn't seem to. I couldn't find anything when I reread the judgment this morning that they've actually decided whether the investigation will or won't comply with Article 2 or...
Yes, my Lord, if you go to page electronic 1924, you'll see the judgment summary. It's paragraph 116. And you'll see at Roman numeral 9, that's the next page, 1925. They're satisfied the decision made by the learned trial judge to quash the outcome of the investigation was well within his area of discretionary judgment. In light of the manner in which the investigation was pursued, it seems unlikely that an investigation by the Legacy Investigation Branch or its successor is likely to engender public confidence. Now, that's a reference back to what had happened in terms of the examination of the Rees memo and the reports that were produced from Kew by the researcher. which you can see and examine those. And one can criticize them as one might mark anyone's essay or homework, but it is a bona fide attempt to conduct some archival research on this topic. It does locate the document, it locates the surrounding documents, places them in context, and we say there's nothing there that would shake public confidence to that extent. But the court did make a finding on that basis, and that is the basis in which the...
Is what you're challenging that the decision to quash the outcome of the investigation by the researcher? Is that what's an issue on this appeal, or
Yes.
what is the issue here?
That's the issue, my lord, and also that the LIB cannot take the matter forward.
Well, they haven't said that. They've just made an observation, which doesn't have any binding effect, I don't think, does it?
Well, I think read together, my lord, it does have a very strong practical effect, and we say that aspect of the finding cannot be sustained. My lord, I see it's turned to sorry, Lord Hodge.
Mr. McGuigan, you said that the researcher had reported in effect that Mr. Rees had retracted his earlier statement about ministerial authorization. What was his slightly cryptic later comment relating to ministerial authorization or the characterization of the acts which had been authorized?
Well, it is slightly Delphic in terms of its expression. I think it's a reference to the way in which the treatment had been characterized as torture.
Yes, I didn't read it as suggesting that there hadn't been a ministerial authorization. He seemed to have backed off the categorization of torture.
Yes, if you read it, and there's a sequence of documents because the Defence Minister, Mr. Mully at the time, raises alarm, I think, at the way in which the language had been used, and that was a concern about the use of the language of torture. And it had always been accepted that there was high-level authorization. That's evident from the debate in the revision judgment. So this was about the way in which that language was used. But it's obviously important that this is read in context. The Strasbourg Court thought so, and the work of the LIB revealed that context. And we say it is something that doesn't confound public confidence, but in fact the opposite.
Yes, thank you. As you said, this is probably the appropriate time to take the 5-minute adjournment. In the normal way, if you just mute your microphones and stop the video, we'll adjourn now. Thank you very much. Mr. McLean, I think we are able to resume. Could I just confirm one point? Your reference to the read across in the Hooded Men of the McQuillan conclusions on independence of PSNI, that was reference to paragraph 71, was it?
No, my lord, I was just going to come to the point, actually, giving too many references too quickly. If you turn to electronic page 1907,
yes.
You will see the Court of Appeal's treatment of this issue at paragraph 47.
47.
Yes, my lord Lloyd Jones asked me about this question, and you'll see all the court says is the court's already dealt with the issue, that's independence in McQuillan. The investigation was carried out under the control of the head, which subsequently legacy investigation branch. In McQuillan, this court found those arrangements lacked the practical independence necessary to satisfy the ancillary obligations under Article 2 and 3. There isn't any more developed analysis of the independence problem in the Hooded Men case. And indeed, it's troubling because it's a very limited analytical assessment, but it's also one constrained. In McQuillan, at least, it was confined to the actions of the police investigating with respect to the military shooting. Here, there is no boundary to it, and we're left with this general finding of lack of independence based on a public confidence problem, notwithstanding the other difficulties in that case.
We see the same point, I think, being made at 71 at 1912. In the light of our decision in McQuillan, it's unnecessary to comment on the submissions in relation to the independence of the PSNI.
Yes.
So there's a direct read across. Having decided this matter in McQuillan, that's it.
Yes.
Yes.
There's there's a lot more at stake in hooded men, and there's quite a significantly different factual framework, we say.
Thank you.
And just to finish with references on that, Lord, I'm sorry I was moving at pace earlier, but in terms of the consideration of the investigation, you'll find that at 1924, paragraph 114, the Court of Appeal found that the investigation conducted by the researcher was unduly narrow and focused on whether there was express information given to a particular minister on the application of torture, and they note their disappointment about that. But of course, when one looks back at what they were tasked to do and the question the policing board asked and the document they were working with, we say that is a rather austere assessment of a good faith activity on the part of the police. And that, again, as I've highlighted earlier, is read across into 116 Roman numeral 9. Lords, I'm trespassing slightly on the time of Mr. Call, but with his agreement, I wanted to deal with just two more points in our submission, and I'll finish within 6 or 7 minutes.
Well, you did start later than your scheduled time.
Yes, Lord, thank you.
So that's fine.
I want to deal with the respondent's point in respect of the common law argument. So the contention here is that even if the Article 2 obligations don't apply in this context, then they arise by virtue of certain common law obligations. And that's a point which we say has been authoritatively dealt with by the House of Lords and the Supreme Court. By the House of Lords in the decision in McCare in 2004, and you'll find that at EF 4783, and it's dealt with at paragraph 30. That's at 4792. You'll see Lord Nichols expressing grave reservations about the appropriateness of the common law now fashioning a freestanding positive obligation of this far-reaching character, be far removed from the normal way in which the common law proceeds. The argument was robustly rejected by Lord Nichols. It's also addressed by Lord Hoffman in detail at paragraph 71. That's at page 4804. Again, the assertion of a broad common law principle equivalent to Article 2, against which the whole of the complex set of rules governing the early investigations can be tested, and by which they can be found wanting and be ordered to rerun under different rules. And his view was there is no such overarching principle. The very notion of such a principle capable of overriding detailed statute and common rules is alien to the traditions of the common law. So that's an authoritative rejection of this type of argument. It was revisited by the Supreme Court in the KU case. You'll find that at electronic 4513, and the references are at paragraphs 117 and 118, and they are at 4563. And you'll see again a treatment there of the argument that there is an alternative approach by way of the common law. That's rejected at letter F. It'd be quite inappropriate for the courts to take it onto themselves through the guise of developing the common law to impose a further duty to hold an inquiry. It would be a duty which have such potentially wide and uncertain ramifications, given it would apply to deaths which occurred many decades, possibly even centuries ago. And at 118, this received strong support from 4 of the 5 opinions given by the court in McCare. And it's of note, of course, also that they observed that that was not diminished in any way by the later judgment in McCaughey. McCaughey, of course, had a general impact on the McCare analysis, but on that dimension, the common law point, it made no material difference. So both McCare and KU, of course, we say, are authoritative on this point, and the attempt to fashion an alternative route by way of common law is, we say, as a matter of principle, closed off to the respondents. But even if one were assessing it de novo, we say that it is not sustainable in this context. As I took time to show the court yesterday, the 2000 Police Act imposes a series of specific statutory responsibilities in the way in which the police discharge their function. And it's directed to securing appropriate public confidence. And I showed the court all of the relevant statutory provisions. I also showed the court the 1998 Act, and Part 8 of which establishes the Police Ombudsman with specific oversight mechanisms for legacy cases and contemporary policing. We say, in light of the carefully calibrated statutory scheme, that Lord Hoffman's observations in McCare paragraph 71 still hold good, and we say that the common law shouldn't be developed to incorporate some form of a Porter-McGill test for unconscious bias into the assessment of policing investigations. And we say it's an unprincipled extension, even with the finessed approach, no doubt, that my learned friends will develop as they make their submissions on this point today. So the common law, we say, is not a route for the respondents. And if the Article 2 analysis of the Secretary of State is upheld, we say this doesn't avail. The last point I wanted to deal with was simply the irrationality aspect of the case, and I think on this point, and given the time, we're content to rely on our written case, which deals with this at page 3908 from paragraphs 191 through to 197. And we say here, the key point is these are ongoing investigations conducted by a highly professional, specialised police organisation, and to intrude by way of quashing orders, stopping investigations, we say, is not appropriate based on a finding of irrationality. There ought to be a due margin of deference afforded to the police in this context, and that's a concept which the Strasbourg Court has repeatedly recognised and affords a margin to police in terms of their operational decision making. So we say the courts were wrong to import the rationality analysis into this aspect of the case. But we refer, of course, also to the Corner House decision and the need for a heightened standard of review in this context. But my lords, in light of the limited time available, we're content to rely on our written submissions in the written case on that. Lord, sorry, I've overrun slightly, but those are our submissions.
Thank you very much. I don't see any questions from the court, so thank you. We turn then to the respondent and cross-appellant's case. And Mr. Savvy, are you opening?
I am, but I think Mr. Cole may have
I do apologise. I'm so sorry. I'm so sorry. Mr. Cole's got his 30 minutes or what's left.
Yes, Lord. Thank you,
Mr.
Lord.
Cole.
I'm grateful, Lord. Thank you. I appear with Mr. McAteer for the Department of Justice. I suspect that Mr. Sully may be able to start making his submissions rather sooner than might otherwise have been the case because of the manner in which my learned friends, Sir James and Dr. McLean, have made their submissions, and it does shorten undoubtedly what I want to say today. And indeed, the timetable, as your lordships will have seen, envisaged a much shorter period of time for the department's submissions in any event, and that is largely because, as was clear from the arguments in the courts below, there is essentially unanimity of approach between the department and the Secretary of State and PSNI on the Article 2, 3 retrospectivity issue and the police independence issues respectively. So I'm in that sense more than happy to have allowed some of my time to go to Dr. McLean this morning. As I've indicated, we associate ourselves with the submissions that have been made on the legal arguments already advanced by Sir James and Dr. McLean. We adopt those arguments, although we do, of course, primarily rely upon and ask the court to note the similar arguments that we have set out in our written case, which for reference you can see at EF 3965. I don't ask you to turn to it immediately. We would make some brief points in support of those submissions from the department's perspective, and perhaps at the outset just to say something briefly about the issue raised by my Lord Hodge towards the conclusion of yesterday's session in the afternoon with Dr. McLean around the parameters of these appeals and how the court might approach the task at hand, and relatedly what should be made of what might be described as the new LIB or PSNI materials. We note and agree with the points made by Dr. McLean that effectively point towards the appeal in McQuillan being academic in nature at this stage. As the court is aware, there is an ongoing investigation in relation to the death of Miss Smith, and that in one sense perhaps changes something of the dynamic in terms of this case, and as it did below, because the Court of Appeal knew when it took the rather unusual step of granting leave to appeal to the Supreme Court itself, that was the situation. So the purpose of the appeal that's currently before this court is in large measure to obtain further and high-level clarity for future operations on, inter alia, the question of PSNI independence. And we respectfully say that that is most usefully done against the up-to-date evidential backdrop, and that backdrop which it does not particularly change the evidential picture considered by the Court of Appeal, but throws into stark relief the problems which arise on the Court of Appeal's approach in making findings in advance about the independence of an investigation which has not yet been completed. So the Department's interest in this case and these appeals is primarily one of principle and of obtaining the Court's guidance and clarity for the future. In that regard, we can look perhaps to the fact that the litigation process has taken some time to get us to where we are today. The Order 53 statements in this case illustrate that. The Order 53 statement in Mr. McGuigan's case dates from January 2015, in Ms. McKenna's case from May 2015, and in the McQuillan case from December 2015. There have clearly been, in the intervening period of time, changes in the composition of LIB and in the nature of its operations and procedures since then. And respectfully, we say that if the court were to blind itself to those developments and not take them into account at all, then there is a real risk that what will result will be guidance that reflects the snapshot position at the time of the original evidential response to the cases as brought in 2015-2016. And that will clearly have perhaps a more limited utility in circumstances where over time the situation develops and changes and results in that net effect that I've referred to of a heightened risk, that in this difficult area of uncertainty, that it will retain further some of that uncertainty with the corresponding heightened risk of further litigation in the near future in respect of these matters. So we respectfully say that there is real value, therefore, in the court speaking to the situation in as up-to-date a fashion as possible, taking account, of course, of the fact that the legal niceties might require careful consideration as to how that might be divided out. More generally,
it is those legal niceties that concern me, because there may be in a judicial review a platform for a senior court to give guidance for future reference. But at the end of the day, it is our task to determine the judicial review before us. And if we are to focus on guidance removed from the issue of the judicial review, are we not in the territory of rolling judicial review, where we are being asked to decide something against a factual background which is different from that which applied at the time of the challenge?
My Lord, with respect, I totally understand and accept the point your Lordship makes, that the idea of a rolling judicial review is rather ominous portent that none of us, I think, would greatly welcome. But I think the point is this, that there is still within the confines of the, as I've inelegantly put it, the legal niceties, there is still an opportunity for the court to speak more generally in an up-to-date fashion in respect of how matters currently stand. And that wouldn't perhaps be entirely unprecedented, that there might be an opportunity for the court to look to the up-to-date picture, and particularly so when one might say that the mainstay of the evidential picture is not vastly changed, simply updated.
Thank you.
Thank you, Maurice. More generally, I think what I see there may be some merit from the department's perspective, given the role the department has as a stand-back kind of overview department looking at this issue, would be to perhaps provide the court with some small degree of insight and to emphasise the scale of the task currently facing the justice system in Northern Ireland in addressing the legacy piece, if one can put that phraseology to it. So to contextualise that, just to say to be clear from our written case, the department and the minister has no role, executive, operational or otherwise, in the conduct of and the decision making around criminal investigations in Northern Ireland. That's not to say, of course, the minister and the department do not have clear interest in taking an overview of the workings of the system. Dr. McGuigan has set out extensively and carefully across yesterday afternoon and this morning the modern day architecture of the policing arrangements in Northern Ireland. It is a system that has been carefully constructed to secure wide-ranging political and societal support, reflecting a clear drive dating back from the days of the Good Friday Agreement and the Patten Commission thereafter to make a move away from the difficult and controversial past of policing that has subsisted from the creation of the state of Northern Ireland 100 years ago, if not indeed even back before that. Fundamental recalibration of policing perhaps finds its most stark resonance in, for example, the Northern Ireland Policing Board and the buy-in to that accountability mechanism by parties across the political spectrum as reflected by the relative strengths of their democratic mandates at Stormont in the Northern Ireland Assembly and the Northern Ireland Executive. It's further reflected by the agreement between the parties to move in 2010, notably some 12 years after the Good Friday Agreement and the Northern Ireland Act, that saw devolution being introduced more generally, to operate devolution of policing and justice functions at a Northern Ireland level for the first time since 1972, a key element of which, of course, was the creation of the new entity being the Department of Justice itself. None of that architecture or those recalibrations gives the Department of Justice, or indeed for that matter the Policing Board, any operational or executive role in policing. The Chief Constable retains that responsibility as per sections 32 and 33 of the Police Northern Ireland Act 2000. And for your reference, I don't ask you to turn to it, but you'll see those sections at EF 4193. The department's position is that that provides an entirely appropriate bulwark to prevent actual or perceived political interference at that kind of operational level. So it's not for the minister to direct the Chief Constable to conduct or not to conduct an investigation, or indeed how the Chief Constable might go about it once that antecedent decision has been made. The department's role is restricted to essentially, in this kind of field, in line with Section 24 of the Police Northern Ireland Act 2000, that the department can determine the long-term objectives for policing in Northern Ireland. It's then for the PSNI and the board to develop same in the terms of policing plans. Alongside that, the department has a power under Section 61 of the 2000 Act to require the Chief Constable to submit to the Minister of Justice a report on matters connected with the policing of Northern Ireland. And perhaps in a similar vein, Section 41 of the 1998 Act, the Minister has the power to call in the HMIC to conduct a report, not just on an annual basis onto the efficiency and effectiveness of the PSNI, but also an inspection into particular parts of the service and particular matters or activities of the police service. Indeed, you heard some reference yesterday to that being a power that's been exercised very recently in the context of the management by the PSNI of the coronavirus regulations at a high-profile funeral in Northern Ireland last year. So the department's interest, as I've indicated, is to seek clarity on the legal issues in these matters, taking cognizance of the structure and the place it finds itself in the structure of an overview role. Respectfully, it can be said that the department will see great benefit from achieving as much clarity as possible in order that it can assess the impact for the justice system for planning purposes, in particular with regard to resourcing and the funding of future legacy commitments. As already set out in our written case, and for the reasons put forward by Sir James and Dr. McLean in their oral submissions, we respectfully say that neither case, that being the McQuillan case or the Hood and Main cases, gives rise to an Article 2 or 3 requirement to investigate. And in any event, as you know, it is the department's case that the PSNI would be sufficiently independent from those under investigation in order to conduct those investigations. And we consider that it may be important and useful for the court to have insight into the surrounding context into which the question that arises under the Article 2.3 retrospectivity issue as to whether the critical date here should be the HRA date of October 2000, or if one could describe it as the Chong date of individual petition, 14th of January 1966, to consider that in that context, when the Human Rights Act was enacted, and for the years thereafterwards, the guiding principle effectively was one of high-level non-retrospectivity. And we see that in the McCare judgment. As time went by, and as a result of, for example, chiefly Sillich in Strasbourg, the investigative duty became viewed as detachable. But if now it is to be treated as entirely detached from the Human Rights Act and to be linked to the ECHR critical date, that will inevitably have an effect of broadening and increasing the extent of cases falling within the investigative duty in domestic law terms, and it will cover the entire period of the Northern Ireland Troubles, if they have euphemistically become phrased as. And the context in which that operates is perhaps a stark one. The population of Northern Ireland is approximately 1.8 million people. In that sense, in an English context, it's roughly equivalent to the population of the Leeds-Bradford metropolitan area. In the legacy sphere in Northern Ireland at the moment, there are 55 legacy inquests. To date, 14 of them have been progressed, 8 are complete. In one, findings have been delivered, but there's an outstanding legal issue. 2 are part heard, and I think 3 currently are listed for hearing in the course of this year and early 2022. Of the remaining 41 cases that are being case managed, there's a plan to hear those across what's described as years 2 to 6, 2021 being year 2, through to effectively into 2026, that having been knocked back from years 1 to 5 because of the coronavirus lockdown impact. Moving from the inquest setting to look to the Police Ombudsman's Office. The Police Ombudsman's Office has in the region of 450 cases currently sitting within its History Directorate, either under or awaiting investigation. So those are matters where the Police Ombudsman considers there is sufficient cause to consider the potential disciplinary or criminal acts of former RUC officers during the course of the Troubles period. Moving from Oponi into the more civil court litigation setting. Yes.
Is this material, is this in the new evidence that's been put in, or are you giving the court some further evidence yourself now?
Well, it's not as much evidence, my lord. It's background, I think, really to the situation as things stand at the moment. So certainly in relation to the Oponi element, I think that may be touched upon. The 55 inquests is not, I don't think it's a controversial matter, my lord. I don't think any of the other parties are likely to take issue with me saying that there are these legacy inquests. And What I was going to go on to do is just to try to indicate the number of civil litigation cases, which amount to somewhere in the region of just under 1,000 probably at the moment. But then one matter that is currently before the court in terms of the new evidence in relation to the PSNI and the cases sitting on the LIB's case scheduling mechanism, but there's approximately 1,100 cases in that category. Now those are death-only cases, and I think there's 1,100 cases and perhaps something in the region of 1,400 deaths involved in those. So, but the point being that it's only dealing with death cases. So, if things widen out further in the context of Article 3 chiefly, then that brings in a much wider range. On top of all of that, there are a number of judicial review matters challenging various issues. I won't go into the detail of that because largely they are parasitic on other issues relating to investigations, etc. So any development that serves to lessen the current control or legal certainty that exists in respect of the parameters of the Human Rights Act obligation will have an inevitable knock-on effect in terms of the allocation of resources and timescales for completion, and that will be all the more so, one might say, if it's accompanied by an outcome that in effect calls into question the ability of the PSNI to conduct investigations with sufficient independence in respect of a large range of these underlying investigations. The court has heard some reference already to the Stormont House Agreement of December 2014. You'll see that, I don't ask you to turn to it, you'll see that at AF 1104. And that's referred to in the affidavit of the deponent on behalf of the department, Ms. Holmes, in the McQuillan case at AF 378, and particularly paragraphs 7 to 15 of that. And I wonder if the court could just turn to that very briefly, please. So you can see that there in Ms. Holmes talks about fully informing the court with respect to current work to implement those aspects of the Stormont House Agreement. Now this is an affidavit that was filed in March 2016, so there's been quite a lot of water under the bridge since then, but your lordships will see therein the position set up by the department as to what the plan was at that stage. What can be said, my lords, is that, again, I think uncontroversial point, that irrespective of the suggestion, in fact, more than that, the agreement in the Stormont House Agreement of December 2014, a body such as the HIU would be established and that it would seek to conduct its work in looking into the matters that had not, by the time of its closure, been addressed by the HET, also into the matters falling within the History Directorate of OPONI, and the further matters relating largely to potential military deaths, which were to be reinvestigated under HET. That there was a 5-year plan, effectively, for HIU to undertake that work. Now we are here in June 2021. As your lordships know, HIU has not been established. And what is clear, one might say, from the most up-to-date position, and your lordships do see this in the written ministerial statement from the Secretary of State of the 18th of March 2020 at AF 570. I don't ask you to turn to it, but it's just there for reference purposes. That it seems at least clear that the UK government's approach to the further investigation of legacy matters has changed significantly from that which was set out in the Stormont House Agreement in December 2014. I may say, well, what's the purpose of bringing all that to your attention? It's largely this. I've already touched on the issue relating to the Human Rights Act and the critical date and whether Parliament might have considered retrospectivity plus as opposed to retrospectivity on a light basis. The impact of that is not to be lost in terms of be it statutory interpretation or considering whether there's been an elective choice by the Supreme Court in, for example, Finucane, and indeed maybe even back as far as McGuigan, in considering how the critical date issue should be assessed. But what's clear is if there's to be a change to it, it will have implications in terms of the investigations of these matters on the ground. And likewise, if it is, as a result of this case, an outcome that seems in effect that large swathes of the investigatory issues cannot be addressed by the PSNI with sufficient independence and with putting in place the necessary requirements to meet practical independence, then the rhetorical question arises as to how are these matters going to be investigated? There is no HIU body sitting waiting to take up vigils, to take up the work. There is limited reach into the ability to bring external in to deal with these matters. Yes, that's been done. Does it provide the solution in the context of the vast number of cases that are in play here? Query whether that is effective or not. So effectively what we say is the scale of the issues arising provides an illustration in the context of the Article 2 and 3 point in one specific sphere as to why Parliament would not have intended the Human Rights Act to apply retrospectively back to 1966. And as Lord Sales noted yesterday, similar problems could arise in the context of other convention rights. And indeed, one also can say that the lead-in period between enactment and commencement of the Human Rights Act tends to point away from any kind of generalised retrospectivity in any event. Of course, that approach runs contrary to how this court has approached all such litigation to date in finding and applying a critical date of the 2nd of October 2000 up to now. So all of this, we respectfully say, supports the legal argument set out by Sir James on the critical date point. And as already said, the Department, for the reasons set out in the Tritton case, supports the position put forward by Secretary of State on the genuine connection test in all respects, but with the same emphasis on the importance of a proper application of the temporal element. Within 10 years of the 2nd of October 2000, we respectfully say is the proper yardstick. In an appropriate case, one can see the potential for 11 or 13 years might be acceptable, but when one starts to move into territory of, for example, arises at KU of 18 years period between triggering event and critical date, the European Court seemed keen, or sorry, the Supreme Court previously seemed keen to shy away from that kind of further timescale. So a base plate of 10 years sets the tone for what a band around that might be. And once one starts to move very much beyond 10 years, it becomes difficult to square that with the wording of a reasonably short period of time. And we respectfully say that in the context of these cases, the court can safely conclude that on no construction can the temporal element properly be met in any of these cases. The significant resource and logistical issues that would arise in the context of the outstanding volume of the extent criminal investigations, if the PSNI were found to be insufficiently independent to carry out those investigations, only would compound what is an already difficult situation. And we respectfully say the Court of Appeal was wrong in law to make the findings that it did on police independence, and indeed was wrong to make those findings on the facts in McQuillan, compounding that error by simply reading it across automatically almost and uncritically into the hooded men cases. And during the session with Dr. McLean, it was asked where one can see that arising, and the court might want to look to, in McQuillan specifically, at, I think it's electronic page 262, paragraph 146, about 9 lines from the bottom, where the Court of Appeal in McQuillan specifically referred to the fact that one has to look to the specific facts of any individual case. And we respectfully say that what is undoubtedly correct on any assessment is that when it came to the hooded men cases, the court's analysis simply didn't go there, it didn't do that. So for all these reasons, the department's position is that it agrees with the submissions made on behalf of Secretary of State and the PSNI on the points of principle, and invites the court to allow our appeals and to dismiss the cross appeals.
Mr. Cole, I thank you very much for your submissions. I don't see any questions coming from the court. And I apologise for misreading the timetable and going to Mr. Southey.
There's a lot of
submissions.
A lot of moving parts in this case, Lord, so that's fine.
Thank you. Mr. Southey.
My Lords, thank you. What I propose to do is address three subjects. Firstly, the temporal limits on the Human Rights Act. Secondly, the particular issues in relation to Brecknell that arise in the case of the hooded men. And thirdly, the issue of PSNI independence. My Netherlands friend, Ms. Quinlivan, will address a number of other matters, and we rely on her submissions, obviously, in both appeals to the extent they're relevant. So starting then with the issue of the scope of the Human Rights Act, I'm going to make my submissions on the assumption at the moment that the Brecknell threshold is crossed in both cases, and as I've indicated, I recognise I need to address that later in relation to the hooded men. I make that point because as a starting point, it's important, because no appellant has suggested that if the Brecknell threshold is crossed, it would not be open to an appellant to enforce essentially their rights that arise as a result in the European Court of Human Rights. And of course, in a very obvious sense, they are new rights, because they are rights that arise from the point in time when the Brecknell threshold has been crossed. The second starting point that we also rely on is that in both these cases, the PSNI undertook to take steps which had the potential to result in criminal prosecutions. And so acts were being undertaken by PSNI. I'll come back to the significance of that in a moment. And what I'm going to do, hopefully, taking account of both of those starting points, is suggest a principled approach to the scope of the Human Rights Act. And I'll do that recognising, or starting from the position, which is, I don't think, controversial given the submissions of my learned friend, Sir James Eadie, that ultimately what is in issue when looking at the temporal limit of the Human Rights Act is a question of domestic statutory construction. And that's not just a technicality. When the European Court of Human Rights is looking at the temporal limits of the Convention, it's looking at whether or not a state should be liable in circumstances where it's a basic principle that it's not liable for things it hasn't signed up for under international law. The HRA, Human Rights Act, is dealing with a different issue, or the temporal limits are dealing with a different issue, because we aren't arguing effectively that the state should be held liable for things that can't be enforced in Strasbourg. We're arguing essentially about whether or not things that can be enforced in Strasbourg should be enforceable domestically. And that, in one sense, is the critical point when listening to, when dealing with this floodgates argument. You've heard a number of submissions about floodgates. We're not here talking about an obligation that wouldn't be imposed on the state in any event. We're talking about an obligation that can potentially be imposed through proceedings in Strasbourg, and whether that obligation should be enforceable domestically. And that's, in our submission, important, because retrospectivity in our submission doesn't arise when effectively you're talking about a new obligation. And that's what you're talking about in our submission in the Brecknell context. conceptually, will not necessarily be as clear as this, we recognise in practice, but conceptually, there will be a day on which Brecknell is engaged. And before that date, there won't be a right that's enforceable. So it is a new obligation. And that's in our submission, the context, as I say, of our submission. So turning to those submissions in a little more detail, in our submission, say the starting point is Brecknell. So James, in his submissions, made the point that Brecknell is about the nature of the obligation. It's not about retrospectivity, and that's right. But it's still an important starting point, and it's an important starting point for this reason. If one turns to electronic page 4829, and I'm taking you to that page because it's essentially where the relevant passages start. The Strasbourg Court, one sees at para 65, was concerned essentially that there needed to be the possibility, one sees in paragraph 65, because it's where it talks about the issues of impunity, there needed to be the possibility of fresh obligations arising where new material potentially comes to life, because otherwise there would be the possibility of impunity. An example being, and this isn't this case, obviously, you can have a situation where there is a perfect investigation, technology changes, DNA comes to light, and DNA clearly shows who was responsible for an offence. In those circumstances, what Strasbourg is recognising is it would obviously be objectionable for the state to be able to say no obligation arises in these circumstances, because it would allow state actors in state cases to act with impunity. And because of that potential for new material, the court was clear at para 69 and 70 that what one is talking about in a Brecknell situation is an obligation that has arisen after, effectively, many years after is the language in paragraph 69, normal obligations to investigate may have come to a conclusion. That's why in paragraph 70, one sees this in the second line of paragraph 70, the court makes reference to fresh obligations. And that's why, in our submission, the court then sets essentially a trigger. And I'll come back to that trigger. And of course, it's significant that on the facts of Brecknell, and one sees this at paragraph 73 and 75, what happened was the allegation, or the investigation rather, concluded 17 years, more than 17 years before the fresh material came to light. No suggestion that the previous investigation was flawed, but the obligation was triggered by new material. And that's obviously consistent with the point that it can be many years afterwards that the obligation arises. And that, in our submission, is the first point of principle that effectively should be taken into account when interpreting the Act. And I'll come on to the Act in a moment. And it's important to say, because it shows, despite concerns about legal certainty, which my learned friend Sir James placed substantial weight on, the European Court was willing to recognise that new obligations essentially can arise because of the need to prevent impunity. And indeed, Strasbourg has continued to use the language of fresh obligations. One reference is, I won't take you to it, is the case of Götekin, which is in the authorities electronic page 8542, paragraph 21. Now, that first point of principle should be read, obviously, with McCaughey. And there may be debates about precisely what this court has decided before, but one of the things that seems to be clear in our submission is that there's no dispute now that the procedural obligations are detachable. So what one is talking about in a Brecknell context is a new detachable obligation. And that's the context of the Human Rights Act. And one of the things that is striking in my submission about what the submissions one's heard so far is that no one has actually referred to the terms of the Human Rights Act. Despite the fact, as I say, there probably is little dispute that one is talking here about the interpretation of the Human Rights Act. And I just wish to remind the court of probably 4 provisions that are important. First, and the reference, the electronic page is 5525. Firstly, one needs to bear in mind in our submission sections 1 and 2 of the Human Rights Act. And section 2, as I'm sure the court is very familiar with, is the provision about interpretation. What perhaps normally doesn't need to be considered is that the interpretive obligation is in connection with a convention right. Convention right is defined essentially in section 1. And that means it is absolutely proper, indeed required, for this court to take account of convention case law when looking at the nature of the Article 2 obligation. And that's clearly what the court has done when it's, for example, taken account of the fact that the Article 2 right is detachable. It's not, though, necessary when interpreting the Human Rights Act. Now, the second group of 2 provisions that remind the court about, which in some senses are even more important, are section 6 and section 22. Section 6, again, as I'm sure the court is very familiar with, requires essentially a public authority to act in a manner that is compatible with convention rights. But that is restricted by section 22, so it doesn't apply to an act taking place before the entry into force of the section. The focus is on acts. Now, that is why we accept there are some cases where, despite the importance of the mirror principle, an individual will only be able to bring proceedings in Strasbourg. In cases where there is no act domestically, the individual will have to bring proceedings in Strasbourg. That's why we would submit our approach isn't unprincipled. Now, except in reality, 21 years after the convention entered into force domestically through the Human Rights Act, those cases are likely to be extremely limited, because the idea that one could bring a case successfully in Strasbourg without having a delay problem in circumstances where there hasn't been an act domestically is probably very limited. But in principle, that limitation still applies. But it doesn't cause a problem in this case, because as we've indicated already, the Brecknell threshold effectively imposes new obligations that arise after a particular date. And the state's response to those obligations is clearly acts for the purposes of the Human Rights Act, particularly in circumstances where the Article 2, Article 3 obligation is detachable. And of course, that's consistent with McCaughey. I'm going to come back to McCaughey in a moment, because McCaughey, my learned friend accepts, applies the convention to inquests taking place. And we'll see the reason for that is because there are acts after the 2nd of October 2000. And that is consistent. Lord Sales raised yesterday the issue of Al-Skaney, or the decision in Al-Skaney. And we hadn't initially put it in the bundle, in part because it's referred to in McCaughey, and it's referred to in McCaughey as an example of the mirror principle applying. But thinking about it overnight, and the way in which argument had developed, it did seem to us that there was some value in McCaughey, in Al-Skaney rather, being put before the court, and in particular the judgment of Lord Roger. And Lord Roger was expressly endorsed by both Baroness Hale and Lord Carswell. And Lord Roger, at para 55, dealt with an argument essentially that the argument that was being put, I think if I remember rightly, by the applicant in that case, that essentially there was a wide territorial scope for the convention, would essentially open up the 1998 Act too widely. An argument that may be seen to have some echoes in the arguments that you heard yesterday and this morning. The response of Lord Roger in para 55 essentially was to say, well, there's a built-in limitation. The built-in limitation in the Act is, of course, you can only bring proceedings if you would be a victim in Strasbourg. What Lord Roger found objectionable or wrong in the arguments that were being presented to support that limitation, that additional limitation, was essentially set out in para 57, particularly the first sentence in para 57, first two sentences in para 57, which was that what the respondent was seeking to do essentially was, for policy reasons, read in a limitation into section 6, which isn't expressly present, for the purpose of essentially narrowing the scope for policy reasons, essentially, in circumstances where that would run contrary to a central purpose of the Act. And that central purpose is clearly the mirror principle. We have that issue here in some senses. If one goes back to the Brecknell situation, the Brecknell case is one where, on my learned friends analysis, there will be cases where, in relation to deaths before 2000, the fact that the trigger has been, or the threshold has been crossed, gives rise to obligations under the Human Rights Act. And my learned friend says that is restricted to cases where there's a genuine connection. The problem with that is the acts to which the Human Rights Act applies are identical. What my learned friend is doing, essentially, is reading into section 22 an additional qualification, this requirement for genuine connection, which doesn't arise in circumstances where, by doing that, he's undermining the mirror principle by preventing people having a domestic right of access to the court in circumstances where they would be able to go to Strasbourg. And that's why in our submission it is important to focus on acts. Now, there is, again, applying the reproach of Lord Roger, a natural restriction. This isn't sort of opening up the courts to every conceivable death that's occurred ever. Firstly, because of the fact you have to be able to apply to the Strasbourg court. Of course, Strasbourg's temporal limit applies. But more importantly, in some senses, more practically, of course, Strasbourg applies delay principles. Come on to delay in these cases later on. But Strasbourg does apply delay principles. And so Strasbourg, the fact one has to be able to apply to Strasbourg means that a Brecknell case, for example, doesn't give rise to unlimited rights. If there's a Brecknell trigger and someone then does nothing in response to that Brecknell trigger, ultimately those rights will be lost because of passage of time. And that all means that there isn't, as my learned friend Sir James Eadie suggested at one point, some issue of constitutional principle. All one is doing here is interpreting section 22 in light of what Strasbourg has said about the nature of the Article 2 right. That was expressly recognised as being consistent, essentially, with the legislation by Baroness Hale and McCaughey. I won't take you to it, but it's paragraph 91, page 4764 of McCaughey. And what Baroness Hale recognised in our submission in that passage of McCaughey was, of course, that when Parliament enacted the Human Rights Act, it would have been well aware that the convention was a living instrument, and so the nature of the rights that could potentially be enforceable would change with time. But that was something that Parliament was willing to enact, fully aware of that. And none of that means one shouldn't just essentially apply Section 22 using its plain language and focus on whether or not there are acts. And that's, in our submission, the correct approach. Now that obviously is a submission which we submit. It is a submission of principle, but I do obviously need to engage with the domestic case law that addresses Section 22 and domestic and the domestic legislation more generally. And obviously, we would accept that McCaughey is a key starting point, because McCaughey is really where this court sought to grapple with the fact, the key principle, which is that Article 2 gives rise to a detachable obligation. And McCaughey is obviously not necessarily an easy judgment to read, not least because there are different approaches taken by different judges, and we recognise that. So what I hope will assist the court if I try and set out what we say are the key principles that arise. And McCaughey is in the authorities bundle, and it's at page 4732, if my notes are correct. I think the relevant passages start. The first principle that we 4732 rather is the start of the authority, yes. The first principle that we draw from McCaughey, which I don't think necessarily is in dispute, because Malone and Prince James accepted essentially that there isn't necessarily a coincidence between the temporal limits of the Convention and the temporal limits of the Human Rights Act, is that what one is ultimately doing is, as I've already submitted is the case, is interpreting a domestic statute. The references to that, I'm not sure I need to go to them, given, as I say, what is probably not in dispute, are Lord Phillips at paragraph 57, where he said the issue is the presumed intent of Parliament. Lord Hope, which is para 77, which was the question is whether there's an Article 2 obligation in domestic law. Baroness Hale, paragraph 82, indicated that in her view the question was whether Scylla had an impact on domestic law. And Lord Brown, paragraphs 99 and 100, in particular, one has to construe the Act in light of the underlying intent of Parliament. So, as I say, in our submission, what that means in practice is that one does have to take account of the European Court judgments when understanding the nature of Article 2, but ultimately what one is concerned with is the effect of Section 22. The second principle, which again, probably don't need to go to the underlying material because it doesn't seem to be in dispute, is that what Scylla decided, and Janovich, although it may have provided greater clarity, doesn't change this as far as anyone suggested, it is that Article 2 and Article 3 are detachable, or the procedural obligations rather, are detachable obligations. And the references to that are Lord Phillips, paragraph 50, it's referring to it being a freestanding obligation. Lord Hope, para 73, the obligation is separate and autonomous. Baroness Hale, para 88, the obligation is separate from the obligation to protect life. Lord Brown, procedural obligation is separate and autonomous. Lord Kerr, paragraph 107, the obligations.
I'm sorry, Mr. Sully, what is Lord Brown's paragraph number?
98.
98.
Sorry.
And after Lord Brown, you mentioned?
Sorry, yes, Lord Kerr, paragraphs 107 and 110, the obligations are distinct and separable, detachable, and Lord Dyson, paragraph 126. And we submit that's the critical principle, and that's the critical principle because it allowed essentially the Supreme Court to conclude that in certain circumstances, the date of death wasn't determinative. It means that there isn't necessarily an issue of retrospectivity when you are looking at, what you submitted, this is the critical issue, current acts that are intended to comply with Articles 2, Article 3. Now that point, essentially, that I just made about the detachable nature is consistent, essentially, with a point, again, which I don't think is in dispute, which is that McCaughey establishes the principle that Articles 2 and 3 apply to inquests. Now that point, I would, if I can, like to spend a little more time on. And the reason I'd like to spend a little, sorry, my lord. So, my lord, we're still.
Yeah, before you move on, I'm just reflecting on the detachable concept. What does it actually mean? What do you have to investigate procedurally? Is it that, well, normally you have to investigate whether there's an arguable breach of Article 2 or 3?
Yes.
Is what you have to investigate whether, in the case of a particular death, there would have been an arguable breach had the convention been in effect at the relevant time? Is that the nature of the procedural obligation? Or what is its scope?
Well, it can. I mean, it can mean that one would have to investigate whether there would have been a breach had it been enforced. I mean, that's clear in one sense from Janowicz and Silla, but in the context, of course, of this case, that's a slightly different issue in one sense, because there's no doubt that Articles 2 and 3 were enforced, and the United Kingdom was obliged to comply with those obligations, because, of course, we're talking about incidents after 1966. The question is whether or not that right is, for domestic purposes, regarded as a separate right that doesn't raise an issue of retrospectivity, and that's where, as I say, the focus needs to be on the terms of Section 22. My lords, looking at the computer on my clock, I was going to go through the third principle, which is as I say, that in principle, the Human Rights Act can apply to inquests, and that is essentially because there are acts for the purposes of the Human Rights Act taking place after 2000. Given the clock on my computer, does it make sense to break now and resume with that at 2 o'clock?
Yes, well, my clock also puts the time at 1 o'clock. So the court will adjourn for the short adjournment and resume at 2 o'clock. Thank you very much, Mr. Zobby.
Thank you.